Take two in an effort to remove the head federal prosecutor for Southern California. There'll be a bail hearing for the man accused of causing the Palisades Fire, and the LA City Fire Department has a new chief. It's the Leonard Files Podcast. I'm investigative reporter Eric Leonard from NBC Los Angeles. It's Friday, November 14th, a roundup of some of the stories we've been following and the events that took place this week, beginning with the attempt, and technically legally successful attempt, by the Federal Public Defender's Office in Southern California to remove the person who has been serving as the head of that office for many months, Bill Essayli, who was at first put into the office as an acting U.S. attorney, and then in July, when the time clock ran out on the number of days you can serve as an acting without being confirmed by Congress and the Senate, the job title switched to interim U.S. attorney, which then caused the Federal Public Defender's Office, which was defending three specific criminal cases, but defends far more than those. These are the ones that were the reason to get in front of a judge, asked a federal judge to remove Essayli, arguing that he was unlawfully holding the office of interim U.S. attorney. And as we've covered previously here, the judge agreed that it was not legal for Essayli to be the interim U.S. attorney after being acting U.S. attorney. But the judge's order, or the judge's ruling, I should say, did not say Essayli had to leave. And in fact, the government's argument was that Essayli wears many hats in the office. And just because he can't have one title doesn't mean he's not going to continue doing the exact same job, but just switching job titles. And that's exactly what happened. In fact, the next day after the judge's decision, Essayli was at an unrelated news conference, and he kind of laughed off the whole thing. He goes, yeah, it's semantics. If I'm not this, I'll be that, but I'm still running the department. Well, this week, the federal public defenders who had pursued that initial legal action and prevailed, the judge agreed, Essayli can't be the U.S. attorney unless he's confirmed by the Senate, Congress, the Senate. And they said because Essayli is continuing to do the same job, but just under a different job title, the federal public defenders have now asked the court to go back and reconsider what happened. Let me show you the filing that was in court this week. This is continuing in these particular criminal cases, which again are not insignificant cases, but for the purpose of this summary and discussion, they're not really the relevant part. The relevant part is that the public defenders are asking the judge to do more than was done the first time. I'm just going to jump down here and read to you from the order, or I shouldn't say order, read to you from the motion for reconsideration of the court's order. It says the court approved Mr. Essayli's continued service without confronting that resulting and still ongoing constitutional violation. And they're making an argument here that Essayli is serving in a role of what's called an inferior officer in the United States government. And they say that is not allowed because Congress has not made any rule and made any law that allows an inferior level officer to occupy that job without a confirmation, without being nominated, without going through all the other things. In other words, you can't have a temporary person in a permanent job just by changing their job titles. There's a lot of argument here about what an inferior officer is, and they point to a number of other situations where people who wield far less authority and power than the top federal prosecutor in a particular place have not been allowed to hold those positions because they haven't been confirmed. They point out, although their work is essential to the operation of the government, our nation's postmasters, treasury clerks, and election supervisors do not make binding decisions about Americans' liberty, as Mr. Essayli does, but all of them have been found to be considered officers under the government rules and laws, which means that they have to go through a process to become one of those officers. They can't just permanently, temporarily hold the job. Again, the result is that a department head like the Attorney General cannot appoint a non-confirmed inferior officer like Mr. Essayli unless Congress passes a law giving the Attorney General that specific power to appoint somebody to the office in question. And the federal public defenders are saying there is no exemption anywhere in the federal law that allows him to continue to serve without a Senate confirmation. That's a requirement of all of this. And they're saying that the potential for the ongoing harm, forgive me for just jamming through all of this, but there's a lot of legal argument about the various federal statutes that apply to how people get into particular federal jobs and some court decisions that have resulted from some of those discussions. I'll spare you all the details, but the essential conclusion that they come to is this. Whatever title Mr. Iseli uses, if he is to wield inferior officer powers, he must either be confirmed or appointed to a statutorily authorized inferior office. And they're saying that the office that Iseli claims that he is in, which he's now signing court documents or putting his name on court documents as first assistant U.S. attorney, the federal public defenders are saying that's not a job that actually exists. First assistant is simply a reference to the existing bureaucratic hierarchy for the purpose of who would do things in the absence of somebody in one of those nominated and confirmed positions. So they're saying that otherwise he cannot exercise the significant governmental authority he claims. The court should bar him from doing so. It should do so both because his continued service is unlawful and because the court is empowered to exclude such an officer in order to incentivize constitutional challenges and to penalize an agency's circumvention of the Appointments Clause. And this is something that came up during the hearing that was held prior to that initial ruling that Iseli was in the job unlawfully, where they were saying, the public defenders were arguing, and the judge agreed in the ruling, that all of these rules that exist in the federal government system for somebody being placed in one of these very significant jobs through an established process and requiring the approval of the Senate is all designed to discourage what they say is exactly what's happening here, which is somebody trying to find another way in. I think they have kind of an interesting way of saying this at the end of their argument here. The Constitution gives the executive, meaning the executive branch, a choice. Follow one of these many flexible paths or secure confirmation. This is the line that they were all leading up to. The solution is not to invent a fifth blank check option. Congress has never written an office of first assistant into the U.S. Code. It has never exempted such an office from the confirmation requirement. Wearing that label, Mr. Iseli cannot constitutionally wield the inferior officer powers he claims, and the court should bar him from doing so. And so to amplify this original decision from the judge who said that Iseli's not holding the office legitimately, the defense is saying, you can't just change job titles, continue to do the exact same thing, have the same authority without following one of the established paths to occupy that job on a permanent basis. The judge did not reject this. The judge that made that initial ruling, J. Michael Seabright, he is a U.S. Court district judge in Hawaii who heard the case here because all of the local or the Central District of California U.S. District Court judges may technically have a role in the person who is occupying the job of U.S. attorney, so they're kind of excluded for a potential conflict of interest. The judge asked the Department of Justice to respond. So he didn't dismiss this as frivolous or irrelevant or meritless. The judge said, yeah, we're going to have some discussion about this. As of our recording, the DOJ hasn't responded yet. They'll file some papers in response to this, and then we'll probably have another hearing about all of this. The significance of this, the takeaway, is that if Iseli is truly barred from participating in the decisions that a confirmed U.S. attorney would make, things having to do with the decision to pursue one case versus another case, or the decision on a particular strategy with pursuing a specific criminal thing, those cases where that person has had a direct hand could be in some jeopardy. We've seen this outside of California with other very noteworthy, nationally significant prosecutions under the current administration where there are significant questions about whether or not the U.S. attorney that brought those prosecutions was holding those offices legitimately, and if not, what is the effect? Because obviously, the line prosecutors in most of these cases are career people who've worked in the office. It's not this elected, appointed, designated, nominated person. But if they had a direct hand in the decision-making, there could be some implications. And the cases where they may have had a direct hand tend to be the ones that are like the biggest, most noteworthy. Maybe the Palisades arson case, where we know Issaili has played some kind of decision-making role in the investigation and what led to ultimately the arrest and the indictment. Which leads us to the next part of our talk today, which has to do with this young man, Jonathan Rinderknecht, seen here in a booking photo. This is when he was first arrested in Florida some weeks back, accused in an initial criminal complaint of igniting the Lackman fire, which you'll remember is the smaller of the two brush fires. This one started 6 days before the Palisades Fire, and the Bureau of Alcohol, Tobacco, and Firearms concluded, it says, in its investigation, that smoldering embers that were buried underground reignited in those really intense winds on the morning of January 7th, and that is what caused the Palisades Fire to grow and explode out of those smoldering embers, making, according to the federal government's logic, Rinderknecht responsible for both fires, not just the one that he's specifically accused in what's now a federal indictment of igniting. The indictment only addresses the January 1st fire. It does not discuss the Palisades Fire as far as the specific charges against him. There's always a possibility there could be a follow-on indictment, what they call a superseding indictment that adds some additional charges. We haven't seen it yet. But the news this week is that his defense lawyer, Steve Haney, has filed a request with the court to reconsider the bail decision. Back when Rinderknecht made his initial appearances in court in Florida, and I'm going to show you a sketch from there, the magistrate judge that heard his initial appearance process, there's a bunch of things that you have to do when you're brought into federal court for the first time, made an initial decision to deny bail, or deny bond, as they say in the federal system, based on the nature of the charges, the fact that Rinderknecht holds dual citizenship. He's also a citizen of France, so there's a flight risk component that was under consideration. And after hearing the testimony of an ATF agent who said that there had been some allegations of threats of violence made by Rinderknecht against members of his own family where he was staying in Florida. Well, during Rinderknecht's first appearance in Southern California in federal court, which was a few weeks back, he entered not guilty pleas to the indictment, and the defense attorney, Steve Haney, told the judge that he wanted to readdress the issue of the bail denial. In the federal criminal system, the person who hears a request for bail generally has to consider that the accusation is true against the defendant. So you sort of go in at a huge disadvantage if you are the accused person, because the court has to assume you did the thing that you're accused of. And so then it becomes an argument about why you aren't a risk to public safety. This is if the defense is making the argument, and why you're not a flight risk. And outside court after that first hearing in Southern California, the defense lawyer said, I think this is a case that deserves reconsideration. He'd already told the judge, the magistrate judge, that he planned to make an application to reconsider bail. And he said that there was a combination of factors that should allow this young man to get a shot at pretrial release. The trial's now set for April, but it's very likely that will be pushed off further because these cases are complicated. The defense has to do a lot of its own investigation, look at having experts come in and look at the evidence, and it could take a long time to get ready for the trial. And in that case, delays are expected, which means that he would be sitting in federal lockup ahead of that, and the lawyer and his family wants him out. He can participate more fully in the defense, is one of the things the defense lawyer said. And because Rinderknecht has no criminal record and he is willing to do things to satisfy some of the concerns about him being a potential flight risk. Usually that means surrendering a passport, possibly wearing some kind of an ankle monitor. The defense wanted to make another argument. So the defense filed a request for that this week. And just yesterday or this morning, the judge approved holding a hearing. So there's going to be a hearing next week on the potential bail consideration, what the terms would be. And we already know the federal government, the prosecutors, are arguing against it. So we probably will not see any kind of a big change from the federal government. If anything, the feds are working on adding more allegations against Rinderknecht. There's all kinds of other factors, and I don't want to go through all of them just because it'll take me a long time and I don't stop talking. But the charges against Rinderknecht so far are only for the January 1st fire, which the ATF says was the cause of the much larger January 7th fire, which became the Palisades Fire, which destroyed thousands of homes and led to the deaths of 12 people. It is not unexpected for the federal government to try to do something about those deaths, make them maybe part of a criminal case. But it hasn't happened yet. So there's a good chance that the discussion at the hearing about bail release may be insightful for all of us that are wondering, well, what else does the federal government know? Is there going to be another chapter or another piece to the criminal charges against him, or is it going to remain limited to that first Lackman fire? So that's going to happen next week. Lastly, this week, the LA City Fire Department now has a new chief. It's Jamie Moore. I will show you a little bit of video of him walking around at the first of two city council hearings on his nomination by Mayor Karen Bass to become the next permanent chief of the LA City Fire Department. Moore has been on the department for 30-some years. He's last assigned as a deputy chief running everything that's going on in the San Fernando Valley, but I know him from when he was the department spokesperson for a time, and when he was a deputy chief in some other roles. He also ran some of the bureaus that deal with internal conduct and misconduct and hiring and things like that. He has a pretty vast experience. You're seeing him there talking to one of the members of the Board of Fire Commissioners. They're the Oversight Board, also appointed by the mayor. So this is from the first of two hearings that Moore was having at LA City Council. The first is in front of the council's Public Safety Committee, which is the group of council members who are supposed to have direct oversight and subject matter knowledge of what goes on in the city fire department, what goes on at the LAPD. And then he had a vote before the full council this morning where the full council endorsed his hiring, so he is the new fire chief. Here's what Moore had to say to the council members at the public safety meeting who asked some questions about the Palisades Fire situation and the problems highlighted by that after-action report, things that weren't done in preparation and things that need to be changed.
Of our department and our city. Recent media attention surrounding the January wildfires has created understandable mistrust, and it must be addressed directly. I fully support Mayor Bass's request for an independent investigation into the Los Angeles Fire Department's response to the Lackman fire, recognizing that transparency and accountability are vital to ensure that we learn from every incident.
So there's Moore talking with the council's Public Safety Committee. There were a few questions about problems in the fire department that everybody knows exist, having to do with budget and staffing and second-guessing decisions that were made prior to the Palisades fire, which, as you heard him say just there, also calls into question the response at the Lackman fire. The big issue with that Lackman fire is whether or not the fire department did a thorough job in extinguishing it. There are indications that there's some issues with how the fire department handled that. The mayor's office, as you again heard Moore say there, has called for a new independent investigation of how the city fire department handled that fire in particular, how it was mopped up and overhauled. We reported last week or 2 weeks ago about this anonymous letter that purports to come from senior members of the fire department, all anonymous, who demanded that there be an internal investigation beyond the after-action report that was already put out. I shouldn't say internal, an external, an independent investigation beyond that after-action report, because they believe something went wrong with the mop-up from the Lackman fire. And then the LA Times reported that there were some text message exchanges where firefighters had reported that they were uncomfortable with the decision to leave that scene when they did. There's video floating around from days after the fire of the ground still smoldering. And so all of that is potentially going to look not great for the fire department, depending on the outcome of those reviews and I suppose how thorough they actually are. On top of that, when the criminal case against Rinderknecht goes to trial, assuming that it does, the defense lawyer has already said this is his defense, that it is not his client's fault that the Palisades Fire started. It's the fire department's fault that they didn't put out the first fire, which means, whether or not that's true or whether or not jurors believe that, the defense is going to dig very deep into questions about how the fire department dealt with the aftermath of that first fire. Lackman fire started at about midnight on New Year's and burned for several hours that night. So Moore's going to have to deal with that. But Moore's a department insider. You'll remember the mayor, Karen Bass, when she decided she'd selected him, said that she'd met with firefighters from all over the city, heard their views on who should be picked. There was a national search done where fire chiefs or aspiring fire chiefs, people involved with other departments, were considered, and then decided it was Moore, someone inside the department who was best to lead. Interestingly, at the Public Safety Committee meeting, there were a number of people from the city fire union who were there to voice their support, which is potentially awkward because Moore is now in the role of fire chief, not necessarily going to have to be their best friend if he's being a good steward of the fire department for the public. There's going to be things that either the mayor demands or the public demands that maybe the union isn't happy with. I'll roll a little bit of the support speakers that came up.
Good afternoon. My name is Doug Coates, and I'm proud to serve as the first vice president for Local 112. I'm here to speak in support of Jamie Moore's nomination to serve as our next LAFD fire chief.
My name is Rich Ramirez. I'm the second vice president of Local 112 and also a firefighter paramedic. I'm here today to speak on support of the appointment of Chief Jamie Moore, and we stand ready to work with him and rebuild his fire department.
Good afternoon, council members. My name is Ryan Quigley, and I'm a firefighter paramedic with Los Angeles Fire Department, and I proudly serve as the Secretary of UFLAC, the union representing LAFD firefighters.
All right, so that in and of itself is not unusual, but there's one thing that occurred to me is like one of those names sounded familiar, and then I remembered we'd done a story some months back about how the umbrella union that sits over the local fire union said it had uncovered what they said was hundreds of thousands of dollars in improper spending of union funds by the union leadership. The union leader, Freddie Escobar, has denied that happened. And last we've heard, the umbrella union called IAFF's calls for a criminal case have not resulted in any kind of action that we've seen. But that umbrella union effectively decertified the LA City Firefighters Union, and one of the three people who was standing there talking is named in the letter that makes this decertification announcement, saying that it was their responsibility to maintain accurate accounting records and be good caretakers of their members' funds. So the support of the union could be potentially complicated. One other issue before we go is that the fire department has been dealing with a payroll problem, which we've covered before. I was looking back through our archives. I think the last stories I did on this were in 2024, but we're going to revisit it, which have to do with the LA City payroll system. The system that was used to pay every employee was developed a long time ago, back when there were no mice on computers. Everything was text entry only. And the city has had this proprietary payroll system that it's existed for decades. and it's beyond life support. It's gravely ill and it's going to die. And it's costing the city millions of dollars each year to continue to maintain that system in order to try to pay people. So 20 years ago, the city should have begun the process of replacing it with updated equipment, but it did not. And then more recently, the city hired the company Workday to develop a cloud-based payroll system that would absorb all of the data from all of the different city departments and begin to replace the old payroll system. But our story from 2023 and 2024 was that this project has been a disaster for the city. Everybody's blaming everybody else. The city is blaming Workday. Workday is blaming the city. The company keeps coming back to the city council for more money. It initially started as a $50 or $60 million project, and the cost overruns had it near or over $100 million a year ago, and it still wasn't working. And one of the things that's been happening is that the method that's used to calculate the pay of firefighters, and even more so police officers, because there's a zillion different categories and bonuses and different ways people's salaries get calculated, is complicated. And each time the Workday system was put online, there were problems with them being paid. And it's not even only related to the actual salaries that are being paid. It's also related to accounting of overtime, which, depending on what department you're in, is either a cash payment or can be compensatory time off. And problems with those calculations are now haunting every city department, including the fire department. And one of the things Moore said, in addition to him supporting the union and being very grateful for their support, was that one of his first priorities, before all others, was going to be to fix the payroll system and figure out how to get the fire department online in a way that gets its firefighters reliably paid. Some of the city departments we're hearing are hiring consultants. So the city itself paying nearly $100 million for a system that is not fully functioning yet. And then departments within the city are expending some of their own money to hire their own software engineers or consultants to try to figure out how to bridge their legacy payroll with this newer system that still isn't working fully in 2025. I'll leave it there for now. I'll continue to follow all of these, including next week's court appearances in the Palisades case. There's some other federal court stuff coming up that's pretty interesting. Be sure to click like and subscribe on our YouTube channel so you don't miss our upcoming episodes. I'll see you next time.